afternoon. Our next case is State v. Melton. The court expresses its appreciation to counsel for your flexibility. We will hear from the appellant.
Thank you. Good afternoon. May it please the court. I am Karen Strickland, and I represent Stephon Melton. I would like to reserve 10 minutes for rebuttal. The right to select counsel of one's choice is the root meaning of the Sixth Amendment guarantee. This court has held in State v. McFadden that this right can only be denied where it would result in significant prejudice or disruption of the orderly process of justice, unreasonable under the circumstances of the particular case. Under the McFadden standard, this is not a close case. In this case, there were not multiple continuances before trial. Mr. Melton made a sincere request to hire his own privately paid counsel. The state was contacted by this private counsel the week before trial. Thus, there was no surprise to the state. The state also articulated no prejudice that it would suffer by allowing Mr. Melton to hire his own counsel. In other cases, the request for counsel was not concrete, it was far more speculative and hypothetical, and the state was concretely prejudiced. Accordingly, we respectfully contend that the Court of Appeals decision should be reversed. I'd like to talk first about the burden that should apply here, because we are talking about a fundamental constitutional right. And there is some discussion in the state's brief, for example, about this being an abuse of discretion standard and the defendant having the burden on a motion to withdraw. Now, we would submit that, of course, the court does have some degree of discretion here in determining matters involving its calendar and what would be unreasonable. But ultimately, this court should not lose sight of the fact that this is a fundamental constitutional right. And the state always bears the burden of showing that it has complied with the Constitution. So under McFadden, the burden is properly on the state. The state must keep its interference with the right to select one's choice of counsel at a minimum. And that is why the state must articulate that it would disrupt the orderly process of justice to allow this to occur. So I think that's a very important point to start with, is that this is a very protective standard towards the defendant, and that courts should make all reasonable efforts. That is a quote from McFadden as well, all reasonable efforts to ensure that the defendant is able to hire his own attorney. Next, I would like to distinguish other cases that have been decided by the Court of Appeals on this issue, because I really don't think that this court or the Court of Appeals has ever considered a case with these unique facts. If you take, for example, Chavez, State v. Chavez, it's cited in both parties' briefs. In that case, the case had already been continued twice. All the state's witnesses were already in the courtroom, ready to proceed, and it was clear that the administration of justice would be disrupted because the state was ready for trial and all the state's witnesses were there. Similarly, in Foster, the case had been continued 3 times already, and in Little, that case involved a retrial following a trial that the outcome was reversed on appeal. The defendant knew about the trial date for months and had been in contact with an attorney for several weeks, but did not make a request for new counsel until the morning of trial. So here, I think you have facts that are very distinguishable. I think key among those facts is that the state was aware of the request for counsel, which again was not hypothetical or speculative. There was actual counsel, paid private counsel who Mr. Melton had been in touch with, who was willing to represent him if the state was willing to grant a continuance. And the state knew about this request the week before trial, which shows that the state was not surprised, the state was not prejudiced. And I think this also goes to these facts, the inquiry before the court, because I think it's very important to look closely at the transcript of the September 12th, 2022 hearing when this issue initially came up, because the state begins the hearing by going into background about the case. And the state says they were not aware of the motion to withdraw until the day before, but the state did not disclose the fact that Mr. Melton had actually found other counsel who had contacted the state the week before, and the state had actually offered a plea to that attorney. So
Did that
yes,
counsel enter a notice of appearance?
that counsel had not entered a notice of appearance because that counsel was specifically requesting that assurance that in order to provide effective assistance of counsel, that she would need more time to be able to familiarize herself with the case.
Did that counsel appear at calendar call the week of trial?
She did not appear at calendar call the week of trial because the state had said they would deny a continuance. It wouldn't agree to the continuance. So I imagine, that particular fact is not in the record, but I would imagine that that was the reason why she was unable to enter a notice of appearance. But I do think it's a little bit of a red herring whether she had entered a notice of appearance or specifically was retained or not, because under the McFadden standard, the issue is whether he was earnestly trying to hire other counsel who was willing to represent him. And clearly he had, and this person was willing to represent him. So the real question here is, did the state articulate a specific reason why a continuance would disrupt the orderly process of justice when the state had advanced notice of this request? The state.
But do you think is it that the state has to articulate it, or just that the trial court has to determine that those factors from McFadden exist?
Well, I mean, I think that's a good point. I think there are kind of two separate issues here, which I do think the burden is on the state to show that it complied with the Constitution. But I think what you're talking about is the state v. Poole line of cases and whether the court, what inquiry does the court have to conduct?
Right, because the court didn't know about the conversation between the prosecutor and this other potential new counsel. So from the trial court's perspective, maybe thinking, well, all I know is I've confirmed I asked this question about ideological differences to try to understand, is this something where I'm not going to be allowed to permit this to go forward because you can't represent the defendant? And then stepping sort of the next logical question of, okay, well then, do you have another lawyer ready to go because were you about to go to trial? And the answer is no. And then the court says, well, that's enough for me knowing that the trial is imminent. What's wrong with that reasoning?
So I think that inquiry didn't go far enough. And I would say that there are two reasons for that. First, we have what I was just speaking about moments ago. You have the state kind of not exactly being completely forthcoming about the facts of what happened here, that the state had actually been contacted the week before. And I think that's highly significant because even under the case management plan for Forsyth County, yes, this request for a continuance was 2 days late. We concede that. But one of the factors about good cause, because continuances can still be allowed for good cause, one of the factors is whether opposing counsel was consulted beforehand. So that should have been disclosed. And then
But he wasn't opposing, or she wasn't opposing counsel at the time because she hadn't entered a notice.
I apologize. I mean the state, the prosecutor. The prosecutor was consulted about the motion, about Mr. Melton.
Can you make a motion if you're not counsel in a case?
I'm not sure I follow your question, but it may be that I didn't clarify. What I mean is the motion to withdraw that was filed for the purpose of hiring new counsel. The facts about the contact from paid private counsel should have been disclosed. And then I think on the other side of that, I don't believe the trial court conducted enough inquiry because while it may have been legitimate for the trial court to try to determine whether there was some sort of impasse, that may be sufficient to allow withdrawal, but it's not a necessary finding. The court should have asked about the actual factors involved in McFadden, and notably, when Mr. Melton was speaking to the court, the court interrupted him and said, this is just a yes or no question. Have you retained counsel? And Mr. Melton was trying to explain the circumstances, and presumably, if he had been allowed to speak, he might have disclosed these very same facts, which were ultimately disclosed the next day. So I do think that the trial court, in order to exercise its discretion to consider the circumstances, has to have actual knowledge of what those circumstances are, and that does require inquiry. And I think the other important point on that is whether or not it was the fault of the state for failing to disclose or the trial court for failing to conduct adequate inquiry, or a combination of both, neither of those things were Mr. Melton's fault. They were not his fault personally, and they were not his appointed counsel's fault, because his appointed counsel did not know about the plea offer or the contact with the attorney the prior week. So that's why I think it's particularly important that in order for the trial court to have had the full information, the state would have had to be the one to disclose that, because Mr. Melton's...
Do you think the McFadden... I mean, because I understand your point that we're looking for the trial court to make this assessment that, and the court doesn't itself even mention, like, what is the impact of potentially allowing a continuance of bringing in, you know, that sort of thing. But my question is, like, is it sort of axiomatic when it's the day before trial that that's like the looming obvious, you know, sort of flashing, this is a huge problem issue, and so it's okay for the court not to mention that because it's obvious that at that stage it's really too late to try to start changing things. And so just the question of, well, have you even actually retained the new counsel yet? And the answer is no, to say, okay, well then that alone is enough to show that I've considered the factors. What's your response to that?
So I think there's a couple of things. I think first on the timing, it should be evaluated from when the state receives notice, not when the motion is filed in trial court. And that is because the state controls, the district attorney's office controls the calendar of cases for trial. The court does have some discretion to move cases around, but when you're looking at what would actually disrupt the orderly process of justice, that falls on the state, that falls on the district attorney's office. And the whole purpose of calendar call is that it is designed to have multiple cases prepared for trial, particularly in a county like this one, Winston-Salem. This is a big county. Presumably there are multiple cases for trial. And so when we talk about the quintessential, this is being made the day of the trial, those cases involve the witnesses are in the courtroom. They are ready to testify. People are there. This motion, even if you go from the date of the motion to withdraw, this was brought up at a calendar call at the beginning of a trial session in September 2022, along with multiple other cases. It wasn't even heard in front of the same judge who conducted the trial. So there was no circumstance where the state didn't articulate, for example, if we continue this case, I'm not going to be able to bring my star witness. The state was not able to articulate any sort of prejudice that would arise when the whole system is designed so that, for example, if a case pleads out at the last minute, the state is prepared, the state can just move on to the next case. And so while I do agree that if this were an ordinary motion to withdraw that didn't implicate a fundamental constitutional right, the court would have discretion over its calendar and the state could say, hey, I just want to proceed. But in this circumstance where there is a fundamental constitutional right at issue, that right has to have teeth. There has to be some sort of standard above just the ordinary, highly deferential abuse of discretion standard, even if the court is allowed to have some degree of discretion over its calendar. So I hope I've answered your question. But no, I don't think that, I mean, again, I think that the timing of this coming the week before trial in a jurisdiction that allows continuances for good cause even after the deadline, I think that that fact is highly significant. I think there's also another aspect of your question, though, that is equally significant, and that is that you have this very unusual factual situation where the state extended a plea offer to defense counsel who had not entered a notice of appearance in the case, but the state did not communicate that plea offer to Mr. Melton's appointed counsel. And that was a new circumstance where a basic professional obligation of counsel is to communicate plea offers. And it's understandable for Mr. Melton to no longer, he didn't like his attorney anyway, he wanted to hire counsel. But this circumstance, which only arose the Friday before trial, really kind of deepened that distrust and that issue, the breakdown in communication, and very understandably so. And so I think that even if the court were to conclude that all of these other timing circumstances that I described were not sufficient, it would still have to contend with this issue about something that was completely out of Mr. Melton's control, that was not his fault at all, that contributed to a complete breakdown in trust in the relationship, that was completely understandable that he would no longer want this counsel to represent him. And so one thing that I would contend is that while I do think that this case is important in the sense of applying the McFadden standard and clarifying the fundamental right to select one's own counsel, I also think that this case would only require a very narrow holding based on the unique facts of this case, which presumably would not arise in any other context, in terms of there being a good cause here for a continuance, the first continuance that had ever been requested in the case, where there are these very unique circumstances leading to a breakdown in trust between appointed counsel and the defendant, that made this supported by good cause, that this was not an attempt to weaponize the request for counsel just to delay the trial. That is clearly not the case based on this record.
Well, I would push back a little bit. It's been a while since I've been in a trial court, but this appears, from my recollection, to be a very common situation where someone who has retained counsel is set for trial, or a court-appointed counsel is set for trial, and someone who purports to be in the process of being retained comes and says, hey, what's the situation with this case? Do we know from the record what the plea offer that was communicated to the purported retained counsel was?
I don't believe that that is in the record, what the plea offer was.
Do we know from the record if that was different from a prior plea offer that was communicated to the defendant?
I don't believe the specifics of that are in the record.
So it could be that it was what was communicated to the purported retained counsel was identical to the plea offer that was on the table leading up to the September trial date.
It's possible. We don't know. The record doesn't disclose that. The only thing that we know is that there was some sort of identification issue that had come up with a witness, and then the plea offer, I guess Mr. Melton rejected it, and then it was taken off the table. But the state's attorney disclosed that there was an identification issue to court-appointed counsel, but did not disclose the fact that this other private counsel had reached out and that there was a plea offer communicated to that counsel. And that's on page 10 of the transcript of the September 13th hearing, where I think the state at first maybe thought that it was disclosed, but then realized, oh, actually, I didn't disclose that. And his court-appointed counsel confirmed that he did not have any knowledge of that plea offer or the contact. So I do think that's highly unusual in the sense that while it's not unusual, of course, what you said, Your Honor, that retained counsel might reach out and say, hey, what's going on? But I do think what's very unusual is that you would have this, I assume, inadvertence of the prosecutor not communicating a plea offer to appointed counsel.
Again, you just acknowledged that it's pure speculation, essentially. We don't know if it's a different plea offer at all.
Sure. I guess I don't know how that's material, though, because to me, it seems like what the point is that he's not understanding, why am I not getting this plea offer from my court-appointed counsel that I did get from this outside attorney, seemingly outside of the system, and that makes me not trust my attorney anymore, my court-appointed counsel. I don't want him to represent me because he's not communicating. He was already concerned about a lack of communication, and his concern is my court-appointed counsel is not communicating to me very basic information, which we all understand is required under the rules of professional conduct. So while it can be chalked up to a misunderstanding, I think what it shows is that his request for counsel was reasonable. It was reasonable, and it was not an attempt to delay his trial. And it's worth underscoring that he wanted to pay somebody on his own so that the North Carolina taxpayers didn't have to pay for court-appointed counsel for a multi-day trial. So it seems like an eminently reasonable request when, again, the state had notice of this, and they didn't have their witnesses in the courtroom. The trial had not begun.
But at the, sorry to interrupt you.
No, you're fine.
At the first hearing, though, the judge asked the defendant whether he had talked to another lawyer, and the defendant, according to the transcript, said, I've talked to several. And then the judge asked him if he had actually employed another lawyer, and the defendant said no. So when you're thinking about what information the trial court had at that first hearing, at least, it was, well, he's expressed an interest in having retained counsel, but he's talked to a few people. He hasn't hired anybody. So
Sure.
what do we make of that?
Well, I think it's important to look at what really the specifics of that transcript, because if you look at what he said, I think words to the effect of, they won't allow me to, and then he gets cut off. And the court seemed to only be concerned with, have you actually retained other counsel to represent you? And I think that if he had been allowed to explain, they won't allow me, what he was trying to say, presumably, is they won't allow me to hire other counsel while my court-appointed counsel is still on the case, because the counsel that I've selected needs assurance that she's going to have a continuance to familiarize herself with the case. He may not have said it as eloquently as I just did, but I think that by cutting him off and not allowing that explanation, those facts that may have come out in the first hearing didn't come out. And that's why I would say, I mean, again, I think it's multiple things on top of each other. I don't think it's entirely the trial court's fault. I think the state also said quite explicitly, we didn't have any notice of this until the day before. And the state most certainly could have disclosed, well, I did have an attorney reach out to me last week, because that is certainly relevant to whether this would be reasonable under the circumstances of the case. Because again, the state is the one that controls the trial calendar, not the trial court. So I would also stress as well, not only did this case not have any prior continuances, but the case management schedule itself sets the goal for how long cases are supposed to be pending before they're resolved, and it was a 12-month disposition goal for this level of felony. So this case had only been pending for 7 months since indictment, so it was well within that goal. The other point that I would stress that I think is very critical on these facts that I might not have said is that the trial date he only had notice of on August 22nd, which is a very quick turnaround. And I think that further underscores that this case is really distinguishable from other cases where the defendant knew of the trial date for months or there were multiple prior continuances. It also explains why maybe an issue had come up closer to the trial date because that may have been when they were in crunch time preparing for trial. So I think I will reserve the balance of my time unless there are any further questions.
Thank you, counsel.
Thank you.
We'll hear from the appellee.
Mr. Chief Justice, and may it please the court. My name is Mark Brunton. I work for the North Carolina Department of Justice and represent the state in this matter. Last-minute attempts to change counsel invite chaos. At best, they slow down our courts. At worst, they expose defendants to prejudice, incentivizing the replacement of trial-ready counsel with unprepared attorneys or pro se representation on the eve of trial. The Sixth Amendment protects defendants' right to counsel of their choice.
So I guess I'm going to cut right to the chase here because I think the thing is if the trial court had said any of what you just said in the hearing, this would be a completely different case, I think. But we've had a case earlier on this calendar. We talked about trial courts that seem to have a misapprehension of what the appropriate legal standard is. And I think that is one reading of what happened at the first hearing here because the court doesn't say anything about, this is going to disrupt the orderly processes of justice and so on. The court asks a question about ideological differences with current counsel that's not relevant to the standard and then says, well, have you hired an attorney yet? And when the answer is no, denies the motion. So you can see how your friend would argue, well, it's not even clear the court engaged in the correct analysis. And then, of course, you have another hearing where the court says one Superior Court judge can't overrule another when that's not true if there's new information that changes the basis for the motion, which seems to be why the motion was made here to begin with. So I'm struggling a little bit with how maybe there were some errors by the trial court here. So walk me through why you think, I understand your rhetoric, but why is what the trial court said in this case adequate under like the McFadden standard?
Thank you, Your Honor. So first I'd point out, as was discussed a bit earlier, there was already just the self-evident fact that this was being made. At the very earliest, the first indication that there might be a desire to have counsel be withdrawn was on the Friday before. The court isn't learning about this until the calendar called the day before trial. So that self-evident fact goes to this both possible prejudice to the defendant and disruption of the orderly processes of justice under McFadden. And then there's this additional inquiry that the court makes into whether or not Mr. Melton had retained alternative counsel and learns that he does not. So the court would then have known that a couple of things could be possible. Either there was no counsel waiting in the wings, so if this motion to withdraw was granted, there would be nobody ready, or at the very best, an attorney would be able to jump in at the last minute but might not be prepared, or a delay would happen to the trial, which gets back at this disruption of the orderly processes of justice.
All right, so there's like two levels of inference, really, is what you're arguing. First is the court must have inferred from, have you hired a lawyer yet? No. That, okay, there's gonna take some time to hire that lawyer, and that lawyer's gonna have to be brought up to speed. And then next inference from that, therefore, we'll have to have a continuance because that means we won't be able to try the case tomorrow. And then the final conclusion must have been having to delay this trial would disrupt the orderly processes of justice because although we have continuances in other trials from time to time, there's a reason why no continuance in this trial. That's what you're saying. And I guess you know where I'm probably heading here, which is that's a lot of inferences built on top of one another here about what the trial court must have been thinking.
Well, Your Honor, I'd say that the most essential fact is that there was no alternative counsel that had been retained. So what didn't require an inference at all is the fact that there was no alternative counsel, and the court would have wanted a little bit more certainty that if this motion to withdraw is granted, there would be somebody ready to step in.
But in the circumstances of this case, doesn't that put the defendant in essentially a catch-22? Because the person that he's been talking with that he wants to retain says quite reasonably, I can only enter an appearance and represent you if we can get a continuance so I have time to prepare. And you're saying, but he could only get the continuance if he already had retained alternative counsel. So he's in this box where he can't satisfy what you're saying he needed to satisfy to get a continuance and he couldn't get an attorney unless he got a continuance.
I think there's a couple of points there to address, Your Honor. I mean, there's the first fact regarding the catch-22. There isn't any rule that says that a appointed counsel needs to withdraw before a second attorney can be retained.
No, but she was saying, as I understand the record, and correct me if I'm wrong, but the attorney who he wanted to retain and who had contacted the state and who had gotten this plea offer, that attorney said, I'm only going to enter an appearance if I know I can get time to prepare for trial.
Yes, Your Honor. It appears from the record that this attorney, A.D., would be interested in coming into the case if a continuance could be granted or if a plea could be reached, and neither of those came to pass. The state wasn't interested in a continuance, and a plea was promptly rejected. So when the rubber meets the road at the time of this motion to withdraw, neither of those conditions that A.D. had put forth had been met. So it was not clear at all at that point that A.D. would be willing and ready to jump in and represent Mr. Melton.
Right. Well, as I understand it, she's saying, I'll represent him if I can get a continuance, and you're saying he could only get a continuance if he already had somebody representing him.
Well, it seems that A.D. asked the state for that continuance, it appears, and the state declined. Whether or not... So there's potentially a possibility that there could have been a motion to continue made at the first trial court hearing at this calendar call, but that was not made by counsel.
Did the state have an obligation to disclose to the trial court the discussion with the potential private counsel?
I think in this situation, it's not clear that they would, because the ultimate retaining of A.D. never came to pass. And so for the purposes of this hearing, that exchange may have happened and there may have been some interest in A.D. being retained. But at the time of the motion to withdraw hearing, that wasn't going to happen anymore. And so regardless of what may have been said in that exchange, it was no longer relevant to the court deciding on this motion because there wasn't anybody there to step in at that point.
Let me back up from Justice Allen's question. Does the state have an obligation to communicate with the defendant's counsel who's made an appearance about offers of plea agreements?
Your Honor, I think there is I would agree with that general principle of that obligation, but to circle back to some earlier discussion that was had, we don't know the full extent to what A.D. was representing to the state over the weekend, the degree to which A.D. might... We don't know whether A.D. might have suggested that there was more of a formal relationship or a very close to an official retainer at that point. So it's very possible that the state could have been confused under these circumstances as to the exact relationship that A.D. had at that moment.
So if that's true, then doesn't that sort of heighten the state's obligation of candor to the trial court to say, we were under the impression over the weekend that A.D. had been retained, and that's why we made a plea offer to her, as opposed, I mean, do you see what I'm saying? Like the two might be related. If it's true that the state was under some misapprehension about the status of the legal relationship between Mr. Melton and A.D., it seems like that heightens their duty of candor.
I don't agree, Your Honor, that it's always preferable to disclose as much information as you can, but we would continue to assert that in this case, those facts were not essential to the determination of this motion.
So just to make sure I understand what you're saying, and I'm focused here specifically now on the first hearing. At that point, and please correct me if I've gotten the facts wrong, okay? What the state knew was there was this person who had at least expressed interest in representing the defendant, but when the state said no to a continuance request, that person said, well, I can't represent the defendant. So what that means, I think, is from the state's perspective at the first hearing, there was no other potential counsel for the defendant. Is that correct?
Yes, Your Honor, that's correct. So just to circle back to some of the just key facts at play in this case, it's important that Mr. Melton didn't give any indication that he might want alternative counsel until this Friday, at the very earliest, at this Friday before the trial, 7 months after this, Mr. Melton had been indicted. The trial court, of course, learns of this matter at the calendar call the day before trial. And as we've discussed, at the time of that motion to withdraw hearing, alternative counsel had not been retained. There were no other attorneys, retained or otherwise, present in the courtroom who could indicate any desire to come into this case. There was no indication that Mr. Melton would have had the financial resources to hire said attorneys, even if they were willing. And there was no indication that said attorneys would also be prepared to take this case to trial the next day. And I think it would be helpful to just take a bit of time to get into some of the facts of State v. McFadden, because I think to get to the heart of understanding this rule and how it was formulated. And in McFadden, we're dealing with a situation where the defendant had retained his attorney 5 months in advance of trial, and his attorney wanted to represent him but needed an additional continuance in order to do so because of a scheduling conflict. And the court denied this request, so a junior associate had to fill in. And this junior associate was meeting with the defendant for the first time 90 minutes before trial and knew nothing about the case until he arrived in court. And so on appeal, this court ruled that the trial court had erred because the choice of counsel should be denied only when it will result in this significant prejudice to the defendant or disruption of the orderly processes of justice. But this court also noted that that right was qualified, and it said, quote, "A defendant has no absolute right to be represented by a particular attorney." So McFadden itself recognizes some of the harms that can inhere in these last-minute substitutions of counsel. And it was very relevant to this court in McFadden that the defendant had timely exercised his right to select counsel of his choice long before the case was called to trial and bore no responsibility for being without counsel on the eve of trial. Now, I've discussed a bit how this catch-22 situation isn't factually accurate, and the fact that there wasn't a certainty that the trial court would have had this motion to withdraw been granted. And Mr. Melton stated that he had talked to, quote, several attorneys, but there is a big difference between being in talks with potential attorneys and actually hiring them. And even if there had been a demonstration of such a willing attorney, as discussed, that attorney would still have been forced to jump in the day before trial. Now, counsel for Mr. Melton cites in brief Alabama v. Powell for the rule that a defendant should be afforded a fair opportunity to secure counsel of one's choice, and this is certainly the case. But there are a couple of points worth bearing in mind here. One, this right to counsel is not unqualified. It is not and has never been the rule that a defendant has an absolute right to acquire counsel of one's choice, regardless of whether alternative counsel has been retained and regardless of how close to trial this is attempted. I've already discussed this court standard in McFadden, how there was no absolute right. And Powell itself spoke of a fair opportunity to secure counsel of one's choice, not an unlimited one. And I would also point to Gonzalez-Lopez, which acknowledged, quote, "a trial court's wide latitude in balancing the right to counsel of choice against the needs of fairness and against the demands of the calendar." And any rule to the contrary, a maximalist approach to right to counsel of one's choice, would open up courts to endless delay, as defendants would always be able to hold up a trial by simply invoking this right. And two, it is just worth noting the egregious facts that the court was responding to in Powell, which are not present here. So the trial court's denial of this motion to withdraw is this perfectly consistent with the right to counsel of one's choice as determined by both this court and the United States Supreme Court. I want to touch a bit on the counsel for Mr. Melton mentioned some of these cases from our state's Court of Appeals. And I think these cases demonstrate that ultimately motions to continue and withdraw have been denied without error under very similar sets of facts where a motion to dismiss or a motion to withdraw or continue was brought at the last minute. And we're not asserting that these facts are a perfect match, but the key facts in these cases are very similar to the ones at issue here and demonstrate that in situations like these, it's perfectly reasonable for a court to deny a motion in this instance. I would point to State v. Little, where a continuance was requested the day of the trial. An alternative counsel had been retained that same day. In that case, a alternative counsel had indeed been retained, different from the situation we're dealing with here. State v. Foster, where the day before trial, the defense counsel learned that defendant's father had supposedly retained alternative counsel, but defense counsel was the only attorney who appeared at trial the next day. And also State v. Chavis, where the continuance was requested the morning of trial. The alternative counsel defendant said he wanted was not present in the courtroom, and there was no evidence that any financial arrangement had been made.
So, and do you think it's relevant that in Foster, the case had been continued 4 times before, and that in Chavis it had been continued at least twice before, and here the case had never been continued before? Isn't that an important relevant fact here?
I think continuances are certainly a fact that a court can consider in ruling under this McFadden standard, but it's also conceivable to imagine a situation where continuances are granted multiple times, and in that situation, a court would have been well within its right under this disruption to the orderly processes of justice to have denied or some or all of those continuances, but chose not to.
Right, but I guess if you're urging us to conclude that here that it would cause chaos and disrupt the orderly processes of justice to allow a continuance the first time one was requested, it just seems to me that the fact that in those other cases multiple continuances had already been granted is important to know, a relevant fact.
Your Honor, we would agree that it's a relevant fact, but not a dispositive one. And I think here the key fact, in addition to the fact that no alternative counsel had been retained, is the last-minute nature of this motion.
But do we have any facts on the other side? That is to say, anything that explains why allowing this continuance of this case, which apparently was 7 months from indictment, why that was going to cause hardship or disadvantage or problems with the administration of justice for the state?
Your Honor, we would suggest that the very nature of a request being at the last minute, right before trial, where the state is ready to take this case to trial that week, is inherently a disruption in the orderly processes of justice. There's a plan in place. The parties are geared up and ready to go to trial, and that's no longer able to happen. I do want to also get at this question of the both whether the court made a sufficient inquiry into these facts and also whether the correct standard was employed. I've discussed a bit the self-evident fact of the delay and the fact that there wasn't any alternative counsel. And I would just point to this court's holding in Poole that a trial court need only make sufficient inquiry into these facts. And we would assert that a sufficient inquiry was more than made here. And also, even assuming that a trial court did initially inquire into whether Mr. Melton would receive effective assistance of counsel by asking about ideological differences, this doesn't taint or destroy this subsequent inquiry under McFadden, and a court would be well served to inquire under both standards to ensure that a defendant's rights are safeguarded in both instances. And as Mr. Melton concedes in briefing on page 22, note 3, questions of impasse can actually be relevant to this question of whether or not the motion to withdraw is being done merely to delay trial, which goes squarely to McFadden. I want to just acknowledge again on the AD exchange just to highlight Justice Berger's point about the fact that AD did not enter an appearance and did not appear at the calendar call. And even if we don't assert that a alternative counsel needed to be formally retained, which we would say would be essential in this case, there's a range of additional things that Mr. Melton could have done and arranged for in this instance to demonstrate that there would have been the potential for alternative counsel. At the very least, having these alternative counsel ready in the courtroom and able to assert, I'm here, I'm willing to jump into this case, we just need this motion to withdraw to be granted. It's a condition I have, but if this is granted, I can happily jump in. And so granting this motion to withdraw, given the fact that this was there was no certainty about this alternative counsel, would expose Mr. Melton to a risk of prejudice, as well as we've discussed, disrupt the orderly processes of justice. I do want to turn quickly to the rehearing of the motion by the second trial court. And under the State v. Duval standard, a Superior Court judge may only modify a previous judge's interlocutory order in the limited situation where the party seeking to alter the order makes a sufficient showing of a substantial change in circumstances during the interim which would justify a different ruling. And here, the circumstances that motivated the first trial court's decision remained unchanged the following day. The last-minute nature of Mr. Melton's request had not changed. Allowing his attorney to withdraw the day before trial would have prejudiced Mr. Melton and disrupted the orderly processes of justice. And allowing that withdrawal right before a jury was called in the next day would have just been even worse. And additionally, as stated, Mr. Melton had not retained alternative counsel the day before trial was set to begin, and still had not retained alternative counsel the next day. So because these circumstances had not changed, the second trial court would not have had the power to overrule the first trial court in this instance. If there are no further questions, I would respectfully ask that this court affirm the judgment of the Court of Appeals.
Thank you, counsel. Rebuttal.
Thank you. Just a few points. I think Justice Dietz mentioned the misapprehension of law that occurred here by the trial court, and I agree that is absolutely what happened here, and I think it ties into opposing counsel's point about whether this counsel was retained or not, and how that showed that the counsel was not a speculative or hypothetical thing. This is precisely the issue, is that it was not for the state to determine whether this was a real request or how committed this private attorney was. Those facts should have been disclosed to the trial court, because that was the trial court's obligation to determine whether this was a good faith request, whether this was an earnest request for counsel or an attempt to weaponize the request for counsel for delay. I would note McFadden itself doesn't set any hard and fast rule that says counsel has to be retained at a certain time. This is a fundamental right in the Constitution. This is what Gonzalez-Lopez called the root of the Sixth Amendment guarantee. It is so important that it is structural error if the court errs in any way in addressing this right and denying this right to a defendant. And so I think that context is very important when we're looking at the facts of particular cases, that it has to be looked at through that lens. I would also note that saying that there's some sort of categorical rule that an untimely request after the continuance deadline it means that the defendant can no longer exercise that fundamental right is unsupported even by the case management plan, because the case management plan for Forsyth County allows continuances after the deadline if they are supported by good cause. And while there is an aspect, of course, in which this motion was untimely, and we concede that, I would also note that there are many aspects of this situation that were completely not Mr. Melton's fault and that were completely out of his control. And this contact with paid counsel and the non-disclosure of the plea agreement to his appointed counsel is absolutely critical.
When you said the motion was untimely, was this a motion for continuance?
It was a motion to withdraw that came after a request to the state, which again, that should be relevant because the state controls the calendaring of cases.
I asked that because one interpretation of what your friend is saying is that this is really on your client and trial counsel for not saying, well, can we have a continuance? I don't have that retained lawyer lined up right now, but I will if I can get the continuance. And so don't deny the motion to withdraw, but grant my motion to continue, but that motion to continue never actually occurred. What's your response to that?
Well, I think that's part of the consequence of the non-disclosure, because his trial counsel couldn't have made that argument. I should say appointed counsel, just to be clear in the distinctions. His appointed counsel could not have made that argument because he didn't know the facts. He did not know that there was a specific attorney who Mr. Melton had selected, who had reached out to the state. So I think that that is such a critical component of this, is that the trial court did not have the information that it needed to weigh, so it did operate under a misapprehension of law. It could not have exercised its discretion.
Couldn't defendant have told appointed counsel about this?
Well, I think that's part of the breakdown in trust, right? Like, presumably that was part of the reason why he wanted new counsel. But no, I don't know that he.
No, I think what he said was there was a lack of communication.
Right.
I don't think he said anything about the integrity of his appointed counsel. So why shouldn't we look at this and say, well, defendant should have informed appointed counsel and asked appointed counsel to request a continuance?
Well, I guess I would respond in this way. I think Mr. Melton did the best that he could. Mr. Melton is not an attorney. He doesn't know what factors are relevant to getting a continuance. He told his lawyer that he was trying to hire new counsel. He conveyed the basic facts the best that he could. And I think that there isn't really anything more that can be asked of him as a client who is entitled to effective representation of counsel under the Sixth Amendment. So I'm out of time, but we would ask the court to adopt the well-reasoned conclusions of the dissenting opinion and to reverse the decision below. Thank you.
Thank you, counsel. Clerk.